Hello, my name is Philip Toney. I am a graduate student at Clemson University as part of the Wildlife and Fish Biology program. And this is part of my oral portion of Exam 1 for Wildlife Conservation Policy. Today I'm going to be discussing the court case Ricky Held et al. Versus the state of Montana. And hopefully throughout this presentation you'll be able to see why this court case is unique, but also why it's an important court case for the future of conservation. So to start, I'll explain a little bit about what the plaintiff's argument was. In this case, the plaintiff was a group of 16 young individuals, and they argued that the state was basically not providing them with part of what their own constitution states, which is the protection of the right to a clean and healthy environment. And the part of the interesting thing about this court case is that the state had already upheld that as a fundamental right in a separate case in 1999. And so the plaintiffs within this case were saying that they weren't upholding this right, which again, the state had already clearly defined as a fundamental right for its constituents. And they were also arguing that the MEPA limitation or MEPA limitation, which limits the state's agencies for making the best choice whenever there's a contract or something like that comes up, it doesn't allow them to consider the impacts of greenhouse gases whenever they're doing those environmental reviews. And so they argued that that was something that the state should look at. And their ultimate goal was to get the state to address not only just climate change, but to review the way that they do those policies. The defendant in this case, again, is the state of Montana. And their argument was essentially that they were just following what the state law was and kind of following the status quo of what had already been there. They also, you can see when you read through the lawyer for the state, their arguments, they kind of want to throw out the arguments of the plaintiffs as just airing dirty laundry, or the way that they say it is airing things that aren't actionable in court. So they didn't feel that they really had a complaint or a case against them because not only was it not actionable in court, but they also said that climate change is this huge global issue. It's not just in Montana, and Montana's emissions were something that it's too small for them to be making any sort of difference globally. So they kind of play the whole card of, we're not a big enough part of the puzzle to really make a difference, so why does it matter? Essentially, is kind of the feel that you get when reading through their argument. So what was it that made this case unique? And really, there's a few things that we can look at that make this case kind of stand out or make it different from some of those before it. One of the first ones I want to look at is that one of the arguments that the plaintiffs brought up was this idea of strict scrutiny, which is a legal concept where the law has to be written basically as precisely as it can be, so that it upholds a right, or so that it doesn't infringe on a protected right. And the plaintiffs brought up this concept, stating that Montana wasn't adhering to this strict scrutiny. And it was really the first court case about climate change that brought up this legal concept of strict scrutiny. So that was one thing that made it unique. Another one was that they weren't seeking any sort of financial compensation. So that's not unheard of in court cases by any means, but it is rare. So generally, when we look at court cases, we see people are trying to get some sort of restitution, or they're trying to get some sort of compensation for whatever had occurred. In this case, they didn't want that. They simply wanted the state to develop some sort of remedial plan to reduce their greenhouse gases and work towards contributing towards the issues with climate change. And the last one is kind of a small one, but again, it's something that is unique for sure. And that is that the age range of the plaintiffs was everywhere from 2 years old to 18 years old. So again, not completely unheard of to have children or people who aren't adults as the plaintiff in a court case, but it was interesting just how young some of these plaintiffs were. So now I want to look at some similarities between this case and some other states and another case in particular. So one of the interesting things about this case is that, again, the plaintiffs ended up being successful or they triumphed in this court case because of that legal language that was included in Montana's constitution. And so it's interesting to look at what other states have similar constitutional rights or have environmental protections explicitly listed in their constitution. Those other states are going to be Hawaii, Kentucky, Maine, Massachusetts, New Mexico, New York, Oregon, Pennsylvania, Washington, West Virginia, again, along with Montana, which is where this state obviously took place. The other thing I want to look at here is another similar based case. That's going to be Juliana versus the United States. That was filed in 2015. It was a group of 21 young individuals who sued the federal government because they said that their right to life, liberty, and property was being violated because of policies that supported fossil fuel interest. So basically, because the United States government was so actively involved and supporting the fossil fuel industry, they were saying that that was a constitutional violation of their rights. So what does this case hold for the future, or how is it going to have impacts moving down the road? First of all, I think it sets up a definite precedent for litigation for those other states that we just talked about that have environmental right provisions, for people to bring cases forward and for those states to hear those. So a state like Oregon or Hawaii may well have similar litigation in the coming years because of this court case. Secondly, I think it gives a good example for complainants seeking to overcome standing and causation hurdles. So previously, this had been pretty difficult in climate-related cases, but again, with this case kind of paving the way, it does set up the ability for complainants in future states or even just future court cases to try to overcome some of those hurdles. And then lastly, I do think it illustrates the value of targeted challenges in law that seek remedy within the court's ability. So basically, that is to say, they had such a direct and obvious outcome that they were looking for. And again, not unheard of in court cases, but that the fact that they were looking for such a specific remedy that the court was able to and had the ability to help with is something that was important within this court case. So in summary, I do again believe that this case opens the door for litigation that will follow, and it'll follow specifically on that idea that people do have a right to a safe, clean, and healthy environment. And so by focusing on that, I do believe there will be litigation within the future, as we've already seen with the other similar court case I brought up. I do think this is going to be something that we're going to start to see more of, and people will be fighting for that better right for the future of both future generations, but the future of their states in particular as well. So I want to thank you for allowing me to talk about this case and explain some of the reasons why I think it was unique. And here is a list of my works cited pages that I pulled information from for this oral portion of the exam. Thank you.